Okay, so I think that we can start. Good afternoon, everyone, and welcome to this live webinar celebrating the release of the special issue of the Journal of Intellectual Property Law and Practice, entirely devoted to the national transpositions of the DSM Directive. My name is Eleonora Rosati. I am one of the editors of the journal and the editor in charge of this special issue. It is a great pleasure and honor to be joined today by the authors of all the articles of this special issue. And if you are in attendance, it is because you are well acquainted with the DSM Directive, its complex history, and also the circumstance that the transposition process has proved to be no less complex so far. Not all the member states have completed the transposition process. As we speak, there are 11 member states that have yet to adopt any measure to transpose the directive into their own laws. And those that have instead completed the transposition process have been doing so, moving in directions that are not entirely homogeneous, up to the point that a valid question becomes whether at the end of all this, we will be having a digital market that is indeed also a single one. So the purpose of today's webinar is, of course, to celebrate our authors, but is also to showcase how different member states have been transposing some of the key provisions of the directive. You have seen the special issue that we have published. There are member states that are represented insofar as certain provisions are concerned, but the purpose of today is also to have a discussion by authors and participants of indeed the solutions regarding the transposition of provisions that have not featured in our special issue. You know that the directive contains an heterogeneous set of provisions. Some of them introduce new exceptions or broaden existing ones. Then there are provisions that codify or erase certain case law of the Court of Justice. I'm thinking about Article 14 that codifies the case law on originality, and Article 16 that instead erases reprobel. And then there are value gap provisions, including the one in Article 15, a new press publisher's right, and of course the crown jewel, which is probably Article 17, and the regime for online content sharing service providers. And of course, there are also provisions of great importance also on a historical level devoted to the contractual relations of authors and performers vis-à-vis their contractual counterparts. Also those, to a certain extent, can be considered as value gap provisions because they are meant to remedy the power imbalances in the contractual relations of these different subjects. So without further ado, I would like to give the floor to our panelists, whom I thank once again for accepting the invite to participate. And I would like to inform all participants that it is possible to use the Q&A function to ask any questions. And then if time allows, we will also have the possibility to raise hands and unmute oneself. So let's start with the provisions of the directive that are devoted to exceptions and limitations. And here I would like to start with Bernardo Calabrese of the University of Verona, who has written an article about the Italian transposition of Article 3 of the directive, that is the scientific text and the mining exception. So Bernardo, over to you and tell us about the Italian position.
Thank you very much, Eleonora, for the issue, the event, and for organizing all this, and for having me. I have to state that unfortunately, after a while, I have to leave the meeting. So I hope that maybe if there is the chance of having a discussion, I am more than happy to do it. Otherwise, I remain available to be contacted if someone maybe has still doubts. Anyway, the time is running, so let's start. The topic is obviously the enactment of the excellent mining exceptions in Italian copyright law. Since we have limited time, I think there is no point in recalling the legal reasoning in detail. I hope that you can follow it in the article, but I would prefer to focus my presentation on the starting idea on one side of the article and some relevant conclusion, in my opinion, on the other side. As a starting point, since we are analyzing the enactment of the new directive, we cannot look back to the debate before its approval. So we cannot call into question all the relevant policy option and the other legal choices that, to tell the truth, were quite debated about text and data mining. So now we have an applicable EU law, we have to deal with it. But at the same time, as we know, Article 25 of the directive leaves room for some flexibility in text and data mining, giving member states the possibility to introduce more permissive rules on the basis of pre-existing exception in EU law. And this can stimulate new developments in this field. And this is exactly what did the Italian legislator with a normative innovation that could appear a minor thing, but it is particularly interesting for two main profiles. One related to the applicable scope of this expansion, let's say, of the exception, and also the systemic value of this provision. In brief, the new Article 70 of Italian copyright law provides for the same exception in favor of scientific text and data mining as provided by the directive, but it extended also to the right of communication to the public. And literally, it says that it is also exempted the communication to the public of the research results when expressed in new original works. This is totally agreeable, in my opinion, concerning the objective, but it creates a few practical issues. Here comes the first profile, the one related to the applicative scope. In the article, I tried to interpret this provision in order to give value to this expansion in terms of better guarantee of freedom of text and data mining for scientific purposes, in particular in relation to the output of the activity, which is not covered by explicitly by the directive, but that could be covered by previous exception and general principles as well. However, this expansion of freedom, let's say, has further problematic repercussions in systemic terms, and here comes the second profile. Actually, in the context of the EU system, with, as we know, rigid exceptions, an enhancement of the condition for scientific text and data mining risks to entail a pejorative condition, let's say, for commercial text and data mining in comparison, because it is not straightforward to transpose this new special norm about communication to the public under the general regime of Article 4 of the directive and the relevant Italian enactment, and instead could be read as a negation, let's say, of such faculty, a denial of such faculty for commercial text and data mining. There are problems concerning the legal basis, for example, in this direction. In sum, I think that the Italian solution is attractive but ambivalent, being appreciable in its attempt to improve the EU discipline in full consistency with it, but at the same time, it perpetuates or even exacerbates the same faults about the dual regime for scientific and commercial, scientific versus, let's say, commercial text and data mining. And that's why I say that even if it's not truly or totally better, at least it is not worse than the EU model. To conclude, this puts forth attention, in my opinion, the very criticized exceptionalistic approach of EU copyright law, and that I think it makes the Italian case of text and data mining even more interesting from this point of view, because it shows well the complexity and the problems of the system, since in this case we are dealing with a policy choice that actually was more liberal in its aim, but that paradoxically risks to end up, as I was saying, with more restraints to this digital activity in general as an unintended consequence in a certain way. That's why this is also an interesting example of all the problems, the structural problems that are still affecting EU copyright law as a whole, and not, of course, solved by this directive. Of course, they go well beyond this theme, but I hope that the article could be useful to contribute to further discussion in this perspective. I hope to have respected the time. And so I give the word back to you, Eleonora, thanking you again for this chance.
Thank you very much, Bernardo. Of course, the text examining exceptions are very important, and there are some member states that actually, before the directive, took advantage, as far as that was possible, of the possibilities already available under Article 5 of the InfoSoc Directive, for example, relying on the research exception. But of course, there was a constraint that indeed the research had to be non-commercial, no? So now in this Article 3, hopefully there is greater room for scientific research also with a commercial flair. But another interesting point about the text data mining is indeed the one that you didn't discuss in your article, that is Article 4, no, of the directive, that is the TDM exception for subjects other than the beneficiaries of Article 3. Can you tell us anything interesting about the Italian transposition of Article 4 that might be of relevance also to our participants? Something that comes to my mind is the fact that the Italian legislator, for instance, did not specify that the reservation that right holders can undertake needs to be in an appropriate manner. So how do you see that going forward?
That's really an interesting part, and we had the chance of discussing it together. And to tell the truth, it is very strange even to justify this omission by the Italian legislator. In my opinion, the provision of Article 4 on this point is so clear and without uncertainties that for sure the only way to comply with it by the Italian system would be to proceed with a sort of consistent interpretation, integrating the Italian norm that does not provide for this specification, that it is really fundamental, as we know, because otherwise for the real digital way of accessing publicly accessible articles and materials on the web to do text and data mining, it is very crucial, the possibility to have appropriate ways, and let's say more precisely machine readable means. And it's really strange that since the Italian legislator has put some attention on the text and data mining discipline, as it is demonstrated by the scientific part, it is strange that it completely omitted this point. It is really important in practice. But I think, as I mentioned briefly in the article, the problem from the Italian point of view could be solved by the necessity, let's say, of consistent interpretation in this way, so to adapt the Italian norm silent on this point to Article 4 of the directive.
Thank you very much, Bernardo. And we remain on the topic of exceptions and limitations, but we travel from Italy to Bulgaria, and we move from text data mining to the teaching exception in Article 5. So I would like to invite Anna Lazarova to take the floor and tell us about the Bulgarian transposition of this provision. Anna, the floor is yours.
Thank you, Eleonora, and thank you also for organizing this event. Hello, everyone. I am very happy to be here and to have the opportunity to present the Bulgarian take on the implementation of Article 5 of the CDSM Directive. The Bulgarian proposal for the amendment of the National Copyright and Neighboring Rights Act was published for public consultation in September last year, and it still hasn't reached its parliamentary phase. So we're still very far from the adoption of the amendment. But the Bulgarian government for now envisages the introduction of a new illustration for teaching exception provision applicable to digital users at educational institutions exclusively and in parallel with the pre-existing teaching exception. Now, the issue is that Bulgaria already has the illustration for teaching exception as per Article 5.3a of the InfoSoc Directive, which is on the broader side of national implementations. It has no restrictions in terms of beneficiaries, and it is technologically neutral. Nevertheless, Article 5 is being transposed in a new Article 26H in a separate chapter entitled Special Provisions for Certain Digital Uses of Works and Other Protected Subject Matter. And in addition, although having no tradition whatsoever in applying licensing schemes for educational uses, Bulgaria took advantage of the opportunity to derogate the new exception for materials primarily intended for the educational market and sheet music. You will probably notice that my personal stance on the directive in general and the new teaching exceptions in particular is rather critical, but I believe that with Article 5, the EU legislator failed to truly address the inherited fragmentation concerning permitted uses for teaching purposes. And generally, I would say that it made a disservice to users in the field of education. And I blame this entirely on the lack of consistency in the directive, because the Bulgarian transposition proposal demonstrates pretty much all the existing shortcomings of Article 5 of the directive. First of all, the provision of Article 5 was introduced without a clear indication of its relationship with the pre-existing educational exception under Article 5.3a of the InfoSoc directive. As we all know, the illustration for teaching exception is not a new concept on EU level. The previous such exception had no restriction in terms of beneficiaries and types of use, and most importantly, it was technology neutral. Of course, because of the optional nature of the InfoSoc exception, it was not uniformly implemented throughout the EU member states. And one of the main goals of the copyright reform was to remedy this inherited fragmentation. However, the EU legislator had to go further and claim that firstly, it wasn't clear if the pre-existing exception covered digital uses. And secondly, that the pre-existing regulation did not allow for cross-border effect, whatever that means exactly. And even though it's not necessarily a false statement, it may have misled a bit the national legislator, in my opinion, because this narrative was apparently extremely confusing, because some of national legislators, including in Bulgaria, but it's not apparently an isolated case either, decided that Article 5, instead of being a mandatory minimum for user right protection, was something entirely new, something revolutionary, and for the first time in EU history. And furthermore, due to its declared mandatory nature, it had to be implemented as a separate clause, notwithstanding the already existing national illustration for teaching exceptions. In Bulgaria, the duplication of the regime of the educational exception was addressed within the Ministry of Culture Working Party with the addition of a conflict rule in Article 26L, which states that the provision for the new digital exception not the application.
Sorry if I interrupt you, Anna. We have
an imaginative collision, in my opinion. Can you hear me now?
Yes, but I don't know whether it was a problem with your internet connection. But you know, we followed everything, but it was not speaking of digital, not entirely digitally excellent.
Sorry.
Please go on.
Yeah. So. Did you hear the last thing about the collision norm, I think?
Yes, we did.
It's still, okay, so educational establishments and digital forms of use will fall under both the pre-existing and new illustration for teaching exception, which is likely to lead to enforcement issues. And the use of copyrighted materials for educational purposes in
now, Anna, we are missing you, so perhaps you should switch your video off so that you can increase the bandwidth.
Will likely become particularly conflict law. Second, sure. Sorry, can you hear me now?
Yes, thank you.
Yes. Please excuse me once more. So the use of copyrighted materials can also be subject to two competing system of conflict of law rules. And the second issue with Article 5, in my view, is that the mandatory exception is not that mandatory after all. The provision gives member states considerable discretion to deviate from its basis in several aspects and contains the option for the exception to be entirely overridden by the mere offer of suitable licenses. And following the directive, the proposed new Article 26H of the Bulgarian Copyright Act introduces in its paragraph 7 a derogation from the exception in respect to educational materials and sheet music. In Bulgaria, there is currently no established or functioning licensing system for the online use of educational materials or sheet music. The pre-existing exception contains no such restrictions. The draft proposal does not address the explicit requirements of subparagraph 2 of Article 5.2 and Recital 23 for the national legislature to ensure the availability and visibility of licenses. So finally, in my view, such an ad hoc decision to exclude certain works from the scope of the permitted use can complicate the activity of educational establishments in Bulgaria, and overall, the amendment can hardly be assessed as facilitating educational uses. And I also believe that the overall effect of Article 5 will likely not remedy the current fragmentation, but may be amplified instead. Thank you very much for your attention, and excuse me once more for the bad connection.
Not at all, and thank you very much, Anna. So just to briefly follow up on what you've said, what are the next steps for the Bulgarian transposition? What you think will happen and when? I don't know.
Yeah, sorry.
Yes.
I think the connection is bad, and I didn't hear a part of your.
What I asked is what you think will happen now with the Bulgarian transposition, and what time frame you think we can expect.
I'm not really sure, because last year was a bit hard for Bulgaria and its politics, because we had 3 early elections in a row. So I don't know, maybe it will take some time for the proposal to enter in its parliamentary stage. We don't have information whatsoever for the draft law at the moment.
Thank you very much. We now move on from the topic of exceptions and limitations to the value gap provisions, in particular Article 15 and Article 17. So insofar as Article 15 is concerned, we hosted the reflections of different authors on the experiences of France, Italy, and Poland, likely in the future. So I would like to start with Zyad Loutfi, who authored an article on the French transposition of Article 15 to share his insights with us. As you may know, France has been the first member state to transpose Article 15 into national law, and it has been quite an eventful start to this new national provision. So Zyad, the floor is yours.
Okay. Thank you, Professor Eleonora, for this introduction and for organizing this event. I hope that everybody can hear me. And okay, perfect. So thank you, everyone in the audience, for participating today. So as the title of my article suggests, I decided to tackle the implementation of Article 15 of the CDSM Directive in France, and I did so in the context of the Odyssey. I did so because this narrative for me was or perfectly described the journey that Article 15 went through in France, simply because, and similarly to how Odysseus had to sail the Eastern Mediterranean for 10 years or so, and dealing with several challenges before docking home, Article 15 in France went through a lot of debate, scrutiny, and litigation before being actually effectively applied in one way or another in France. So that said, and in order to present this Odyssey within our limited time frame today, I won't be getting into a lot of details with regarding to the French transposition, but I suggest to briefly take the audience through a series of chronological events that depicts and highlights the odyssey of the French press publishers' right, and following which I shall conclude with some concluding remarks. So the odyssey starts with Article 15 being transposed into the Intellectual Property Code through a simplified examination procedure, as Professor Eleonora mentioned. France actually transposed only Article 15 through this procedure, and in order to ensure the introduction of this novel related right as soon as possible into the French Intellectual Property Code. The novel right came into force in France 2 months later in October. However, before it even coming into force, Google announced on the 25th of September that it will only be offering what is called a royalty-free scheme. So they refused in France and elsewhere across Europe to accept this novel right. And therefore, given that Google has 92% of the market share when it comes to this particular industry, a complaint was lodged in November 2019 by 3 major unions representing major French publishers. The complaint was lodged before the French Competition Authority for this blunt refusal to remunerate them and for a possible abuse of dominant position according to EU laws. This led to the Competition Authority handing down its first decision after several months of scrutiny on April 2020, and having found out that the existing mutual bargain between both parties was in fact disadvantageous for the publishers, and they ordered Google to enter into good faith negotiations with the publishers in France. Undoubtedly, Google swiftly appealed this decision before the Paris Court of Appeals. And the Paris Court of Appeals on October 2020 upheld the decision of the Competition Authority. After that period, Google started to enter into what we can call good faith negotiation with the interested parties through what they named back then their Google Showcase Partnership. However, analyzing this remuneration scheme, we can quickly realize that Article 15 was a simple accessory component of the remuneration proposed, and not the main aspect of the remuneration or the scheme that was implemented by Google. That was October 2020. And again, this was Google testing the patience of the Competition Authority, who handed down its second decision in July 2021, imposing a hefty penalty of 500 million euros on Google for its failure to comply with the first decision, and obliging Google for a second time to re-engage in good faith negotiations. Otherwise, a set of penalties and injunctions shall be applied to force Google to comply with the new injunctions. So now here we can simply pause the Odyssey and analyze these events, or the events that we discussed, and especially the usage of EU competition law to enforce intellectual property rights against dominant undertakings. So on the one hand, from a legal point of view, only Google News paid the price since they have 92% of the market. However, since under EU laws, the threshold for any undertaking to be considered in a dominant position, the threshold is set at 40%. This means that other platforms still somehow escape mandatory negotiations. So the usage of EU competition law is somehow criticized in France, as it should be noted that Article 15 and the objectives of the directive meant that Article 15 should be a negotiation tool against both dominant and dominated news aggregators. So that's the whole debate when it came to using competition law to enforce intellectual property rights. However, on the other hand, and from a more practical point of view, the Competition Authority got 92% of the market to respond to the rule of law. And through this complicated path of using competition laws, other platforms started to commit themselves to a payment mechanism, or to paying remuneration to publishers. And to give some examples, Meta, so the holding company of Facebook, in anticipation of launching Facebook News in February of this year, they signed an agreement with one of the unions back in October 2021. And on March 3rd of March 2022, Google reached a similar agreement with the same union. And recently, a month ago, on the 11th of May 2022, Google announced through their blog, which they used to somehow criticize the adoption of the right in the beginning as well. So they used the blog to say or to announce that 300 media outlets will be remunerated across Europe through their new scheme that they call the Extended News Previews Scheme, so ENP. So to sum up, the French solution is somehow practical, but also criticizable. And to conclude, we just simply need to remind the audience that platforms do play an important role in ensuring the vitality of this industry, so the press industry on the internet in this virtual world. And just like the gods in Homer's Odyssey, Google or any other platform has to be bargained with in order to bypass the challenges and to ensure remuneration and not to incur their unnecessary wrath. And I guess that we'll have to wait and see the reaction when it comes to this new Google scheme that is being proposed. So to conclude, finally, I can say that the Odyssey still continues and we don't know how things will evolve. So thank you everybody for your attention, and I hope it was clearer than my article.
Thank you so much, Zyad. So I think that the French experience, first of all, is in contrast with historically what happened in Germany, no? Because of course, this EU press publishers' right follows up on unsuccessful, if one can call them like this, experiences in Germany and Spain, because also there, through different mechanisms, the objective was to support the press in some way. And indeed, in Germany, the instrument chosen was that of a related right. And indeed, Google initially refused to negotiate licenses. There was also the involvement of the German Competition Authority, which adopted a different stance to the French Competition Authority. So I would like to ask you, how important you think has been the robust stance taken by the French Competition Authority in also suggesting a greater chance of success of the EU press publishers' right vis-a-vis the earlier national experiences? So without this French Competition Authority stance, do you see that there might have been again a replica of what had happened in Germany a few years prior?
I think that the French way of implementing Article 15 is somehow criticizable. And again, it was a Hail Mary, it was a last call, last resort, in order to engage platforms to respect Article 15. And again, it is criticizable from a legal point of view, using competition law to enforce intellectual property on only dominant undertakings. Because again, as I mentioned briefly, other platforms who also have a certain market share, not necessarily 92%, they escaped any sort of mandatory negotiations. So the usage of competition law is highly criticizable. But from a practical point of view, it is somehow deterring, and it has its effects, and it maybe saved France from going through a different type of hassle and pleading, press publishers pleading their case before the French judge, and having to go through with extra years and prolonging the odyssey of French press publishers. So again, we'll have to wait and see. And just for the audience to know, all the decisions that were issued by the French competition authorities, they are simply injunctive measures. So still the case is pending before the competition authority, and the latter can at any time issue its decision on the merits if it deems that Google is not respecting the injunctions that were imposed. I guess we'll have to wait and see, because as I said, the ENP scheme that they proposed just got introduced less than a month ago. So the odyssey still continues, and we still need to wait to see the reaction from the public and from the platforms as well.
Thank you very much. And I think that with this answer, you have also answered the question that we received from a PhD candidate in Croatia regarding indeed the French experience and the involvement of competition law tools. So thank you very much, Zyad. Let's now focus on the Italian transposition of Article 15, which to some extent was prompted by the difficulties that the Italians were seeing the French to be having with their own transposition of Article 15, and the idea that a different type of mechanism would be preferable to ensure that indeed this licensing system would start working. The Italian transposition of Article 15 indeed has been at the center of attention also internationally, and we are happy to have Caterina Sganga and Magali Contardi discuss their take on indeed the resulting Italian right. So thank you very much for joining us, and the floor is yours.
Thank you very much, Professor Rosati. Well, as you mentioned, Professor Caterina Sganga and briefly in our paper we suggest that the Italian solution is not entirely consistent with European law. So because of the limited time, I will highlight which aspect of Italian transposition are particular, and then Professor Sganga will explain why we believe that some indications given by the Court of Justice and the European Commission may be invalid. And of course, then we are happy to take any question. So as you may know, Italy was one of the countries that implemented the directive late. Actually, the decree arrived in November 2021. And for Article 15, some aspects that were taken verbatim. In other aspects, the Italian legislator made use of the degree of freedom left by the directive. And among them, our papers focus on the negotiation and licensing scheme adopted for the exercise of the press publisher rights. And to go straight to the point, let's say in the Italian legislators required, let's say, parties to negotiate, let's say, a contract of the amount of the fair compensation. That is the language that the law use. And this negotiation has to take place, let's say, with the guidance of some criteria that the Italian Communication Authority, the AGCOM, was supposed to give with a decree, let's say, that was indeed supposed to be issued within 60 days from the entry into force, which we are still waiting. And then if, despite this, let's say, the publisher and providers don't reach an agreement on the amount of this compensation within 30 days, from the negotiation, each party could request, let's say, the other authority to set the amount. And then the AGCOM had 30 days to decide which of the parties' proposal was more in line, let's say, with this famous criterion. And if none of these proposal, let's say, was close to the criteria, then the authority could determine ex officio the final amount. But not only, let's say, the negotiation was mandatory in this sense, because once the final amount is set, if the parties, let's say, still don't stipulate the contract, then each of them, so not just the publishers, but also the providers, may refer the case to the competent court of first instance. Also, the law says to introduce proceedings for abuse of economic dependence. So, and this prevent, let's say, among the remedies, the compensation, but also the specific performance. So this implies that the publishers may be obliged, let's say, to conclude a license with providers. And there is where the main issues of validity, let's say, come. So I pass the floor to Professor Sganga. Thank you.
Thank you. Thank you.
And thanks, Eleonora, for having us today and on the special issue as well. I will briefly highlight those elements which we believe are controversial vis-a-vis what EU law is telling us, and the reason why the Court of Justice might be, on the one hand, very soon be called to decide on the matter, and on the other hand, might well rule that under certain interpretation, this solution is invalid. Now, you may know that during the phase of the implementation, the Commission was inquired by some MEPs, and particularly by MEPs Vondra, whether Article 15 of the CDSM Directive allowed states to provide for a licensing scheme structured as a mandatory collective management. And the answer of the Commission was radically to the negative for one single reason. Very straightforwardly, they said that mandatory collective management would mean that Article 15 would be transformed from a preventive right to a remuneration right. And that's not something that Article 15 allows. This is perfectly in line with two decisions of the Court of Justice, which we had in the past years that are also relevant for the case at stake and we analyze in our article. Of course, here I won't enter into details of the cases. I will just mention them and tell you what are the relevant aspects of those cases that may suggest as a particular interpretation of the in/validity of Article 43 of the Italian author's right implementing Article 15 CDSM. I'm referring to Soulier and Doc on author's right and Spedidam, which is specifically on related rights. Now, in both cases, one on the validity of a French decree on out-of-commerce works, and the second on the automatic attribution to INA, Film Archive Institution of France, of the possibility to negotiate and collect remuneration instead of performers for broadcasted works on National Broadcasting Company. Now, in both cases, although with different takes, the Court of Justice was clear in stating that national laws cannot transform preventive rights into remuneration right by subtracting the authors of its right to give his or her prior consent to the exploitation of his or her own exclusive rights. Now, the key is the sense of prior consent, because in both cases, the court argued that presumptions or mechanisms that affirm or give the possibility of finding an implied consent are allowed to the extent that conditions are clear and there is a possibility for authors to opt out at any time. Now, if you transpose this clear statement to the case of the implementation of Article 15 by the Italian legislator, the mere fact that you have not just a quasi-mandatory licensing scheme, but the fact that also providers may trigger the imposition by courts of injunction imposing a duty to contract on them under the provision on abuse of dominant position is potentially stripping away from right holders the possibility to decide whether not to negotiate with providers, so imposing a duty to contract at the end, which is no prior consent or even implied consent. So that's the point, which might be well solved by the authority, the AGCOM, through its regulation, but it's still yet to be enacted, so we don't know what the content will be. If this part will be corrected by the regulation by stating that the abuse of economic dependence rule should be understood as to be applicable only on providers and not on right holders, then this problem might be solved. Otherwise, what we argue is that even if everything else is considered to be valid with a very lenient interpretation of Article 43 of the Italian Copyright Act, this part is not going to stand the filtering and the scrutiny of the Court of Justice in line with its case law as it stands now. So happy to take any question or engage in any further debate on this. Thank you very much.
Thank you very much to both Caterina and Magali to this duo of cases that you've mentioned. Perhaps I would also add the judgment of the Court of Justice in the Polish challenge to Article 17, in the sense that there the Court of Justice, I think twice, stressed that right holders are in a position to decide whether to grant a license or not. No? So if that is true for Article 17, I don't see why it should not be the case also for Article 15. And this might strengthen a finding that indeed the Italian solution, no, with all the good intentions that he might have had, presents several indeed risks of incompatibility with EU law, as you have well outlined. So perhaps as a follow-up question on what you've just said, regarding this AGCOM regulation, Do you have an idea of the time frame, and how do you think these problems could be remedied in these regulations? What should the Italian Communication Authority say?
There is still nothing tabled, nor any leaks, so it might easily be that we will go after the summer, and that's the projection up to now. In terms of content, what we are suggesting in the article, of course, is just hinted, but thanks for the possibility to opine a bit more on this. There are two aspects which needs to be addressed. The first one refers to the, as I said before, limiting the injunctions available for providers against right holders, and that would be the first step. The second would be to clarify the criteria that have to be followed when you calculate the amount due to right holders. Because up to now, what Article 43 of the Italian Copyright Act is listing, those are criteria which are just partially referring to the actual value of the news, so they are really following the guidelines of Article 15. Other criteria, such as, for example, the general investments which were made by the publisher to develop their own platform and so forth, they might not be fully in line with what Article 15 is saying, and for this reason, they might be even censored along the lines of what the Court of Justice did in Padovan and its progeny on the private copying exceptions and the calculation of the private levy schemes. So at least those two elements would need to be clarified, and several other aspects would probably benefit of stricter regulation by AGCOM, but this would be already a good start.
Thank you very much. I would like to remind the participants to feel free, of course, to raise any questions and comments by using the Q&A function. We will be discussing the Spanish transposition of Article 15 in a bit, but now we move on to a member state, Poland, that has not yet transposed the directive, and indeed we decided to publish an article by Michalina Kowala on the Polish debate around the transposition of Article 15. So, Michalina, what is going on in Poland? Please tell us. Thank you.
Thank you for the floor. I will just share my screen. Can you see it?
Yes.
Okay, so thank you for the floor again. I'm really glad to participate in this webinar and grateful that I could contribute to the special issue of your journal. I'm a PhD student from Adam Mickiewicz University in Poznań in Poland, and my PhD thesis is about the press publishers' right from Article 15. In my article, I examined the Polish proposal for the transposition of this article, but saying the Polish proposal is a little bit too much. Because unfortunately, my country is still at the initial stage of the implementation process. The draft bill has not been published yet. What we have are the legal objectives made available with the information that the draft will be published in the second quarter of this year. The Polish legislator explains that the delay was caused by the wait for the European Commission's guidance on the application of the Article 17 of the directive. But it's worth noting that the guidance was issued in June last year, and the directive has yet to be implemented in Poland. The main purpose of my article was to analyze the legal objectives of the Polish transposition of the press publishers' related right and to assess how this regulation may complement the protection granted to publishers in Poland. Firstly, I focused on the current legal context related to the protection of publishers in Poland. The main objective was to identify the existing framework for protecting publishers' interests. I analyzed the publisher's right to first edition which is the related right adopted in Poland in 2000 as a result of the national transposition of the directive on the term of protection of copyright and certain related rights. It is held by a publisher who has lawfully published or otherwise disseminated a work whose term of copyright protection has expired or has never been protected by copyright. Then I examined the publisher's right to collective work from Article 11 of the Polish Copyright Act. I studied especially the scope of protection resulting from this right and its beneficiaries. After, I moved to the analysis of the legal objectives of the Polish transposition of the related right. Poland does not plan to introduce the definition of press publisher. When it comes to the Polish definition of the press publication, it does not differ significantly from the definition introduced in the directive and in other member states within the implementation process. However, it should be highlighted that the legislator refers in the definition to the literary works without mentioning that the press publication can also include other works or other subject matters. Poland will implement the exclusive right of press publishers to reproduce and make available the press publication on demand by internet service providers. However, the Polish objectives do not include the details regarding the criteria to calculate the press publishers' remuneration. What I find interesting in the Polish objectives is the way how the authors' revenues are proposed to be regulated. In Poland, authors of press publications will participate in the revenues obtained by publishers from the new related right with an equal 50-50 share. It was assumed that it fairly reflects the contribution of authors to the creation of a press publication, and this solution was supported as well by the authors' associations in Poland. The exercise of the new related right in Poland will not be subject to the mandatory intermediation of collective management organizations, but in this regard, the legislator has gone against the calls made during the public consultation. To sum up, my objective was to analyze the Polish transposition and to determine how this is fit into the framework of protection already granted to publishers in Poland. Now, I would like to present my three main conclusions. In my article, I discussed the important differences between the Polish objectives of the transposition of the related right and the related right to first edition, like, for example, the scope of protection or its term, which varies significantly. Therefore, my first conclusion is that the new right expands the protection of publishers and may be perceived as a new element in the framework of related rights. After the analysis of the relation between the new related right and the right to collective work, I agree with the argument that the press publisher's right in a way duplicates the copyright protection under collective work. My second conclusion is that the new right addresses the publishers who already enjoy comprehensive protection, which may result in an excessive protection of this group. And the third conclusion is that the Polish project is not very innovative by copying Article 15 or by following the solutions already adopted by other member states. In Poland, we say that hope dies last, and therefore it remains to be hoped that for the Polish legislator, the effective protection of press publishers is important, and the final draft of the national transposition of the DSM Directive will be published soon. Very soon. Thank you very much for your attention.
Thank you so much, Michalina. Certainly, this discussion around Article 15 is quite engaging, to say the least. You mentioned in your presentation that the Polish legislator may not be wanting to define what a very short extract is, no? While there are some member states that have opted, for different solutions. I'm thinking about the French, the Italians, that define the very short as something that does not dispense one from consulting the press publication. And there are countries like Lithuania that adopted a quantitative threshold, the number of characters. So I would like to ask you, but which approach is it better? To leave it to a case-by-case assessment, or instead to provide for a definition in national law?
It's a good question. And I think that we will wait for the answer. I think that the Polish choice is right here, just to leave short extract as they are. And I think that the cases will show us more. For the moment, I'm not sure if the adoption of the definition is the right choice, but still, I think that we should wait and see what the Court of Justice will say here.
Thank you very much. I personally find that if there was the need for a statutory definition, then the EU legislator would have provided one. So I'm not sure that these national efforts will pay off in the long run, also because they will clearly create a fragmentation problem, because what is very short in accordance with the Lithuanian law might not be in accordance with the Italian law, and so on. So I think that we find this problem also for other provisions, including Article 17 of the DSM Directive, which we will be discussing now. As you know, the very definition of online content sharing service provider refers to these large amounts of copyright content, and in its guidance on the application of the provision, the European Commission clearly said that you should not be providing a statutory definition of what large amount actually means. It is something for a case-by-case assessment. So indeed, on the topic of Article 17, we will be discussing the Spanish transposition of Article 15 with Miquel Peguera in a short while. We are very pleased to have the experiences of two different jurisdictions to share with you who are following. And it is indeed the Finnish debate, which is not certainly isolated to Finland, because similar discussions are also taking place in other Nordic countries, and I'm thinking in particular of Sweden, and the Italian transposition of Article 17. So let's start with Samuli Melart, who will be telling us about the discussion in Finland on how to properly transpose Article 17. Samuli, thanks for attending. The floor is yours.
Thank you, Eleonora. So hello, everyone. I'm Samuli Melart, as introduced. So my part here today is to brief you my article on Finnish experiences from transposing Article 17 provisions on use of protected content by online content sharing service providers, OCSSPs in short. So as a backdrop, a few months before the call for articles for this special issue was announced, Finland had just published its first draft of the legislative bill transposing CDSM Directive. This milestone was reached with open and stakeholder-inclusive process, including discussions, workshops, and hearings divided into different packages. The draft bill was subject to public consultation round for stakeholder feedback, after which it was put into follow-up preparation. This was followed then by a period of radio silence from the ministry. During this time, I started writing the article on Finnish implementation of Article 17. In February, the ministry then arranged a public hearing with short notice, where it dropped the bomb that many sections of the bill had undergone complete rewrite, including provisions transposing Article 17. And as a cherry on the top of my cake of misery, the ministry was against publishing the actual text of this new draft until it had communicated to the parliament the actual bill, and was merely providing a summary of the main points in PowerPoint presentation. This made me doubt whether I could even write the article initially, but luckily the ministry changed its mind and opted to publish the draft bit still in March. The rewritten provisions transposing Article 17 were drastically different from the first draft bill, so I ended up comparing the main differences between the first and this new second draft bill. There has also been a lot of concern in the public over the circumstances surrounding the drafting and the policy process leading to the second draft bill. So in my paper, I also briefly addressed this process itself a bit. And the two draft bills had a completely different approach in their implementation technique towards Article 17 provisions. The first draft used the national marching to completely rewrite Article 17 provisions with a unique structure, its own interpretations and conceptual constructions, filling many gaps that the CDSM Directive notoriously left unaddressed. These were argued to be necessary in the preparatory memorandum of the draft bill, as Article 17 lacks specificity and concreteness, while highly sensitive fundamental rights questions were at the stake. The second draft retracted from this position and adopted highly agnostic and restrained approach. So many of the provisions were instead directly taken from the Danish and Swedish proposals of Article 17. This change in the approach was mainly explained with the negative feedback received during the consultation rounds, and systemic coherency needed to be promoted towards the other Nordic countries. And by the substance, the two draft bills were also very different. The first draft bill was more concrete and focused on stronger ex-ante approach to fundamental rights safeguards for the users of the OCSSPs. In its explanatory memorandum, Advocate General's opinions to Polish challenge of the Article 17 was extensively used to construct national interpretations how to balance different rights and responsibilities between key stakeholders, and where to draw the line for automated methods of blocking and removing user-uploaded content. The second draft bill clearly weakened the pre-ante fundamental rights safeguards, both in the paragraph level and in the explanatory memorandum, while introducing some additional property right considerations here and there. A majority of the references and constructions based on Advocate General's opinion to the Polish challenge were scraped off. So the difference between the two draft bills can be exemplified the best by comparing how the threshold for the use of automated methods to block or remove content from the platform were implemented. In the first draft bill, the platform is obliged to remove content only where the content is complete equivalent to a subject matter that the right holder has requested to be removed. If the content is not complete equivalent, or the user has flagged that the use of the content has legal grounds, whether based on law or contracts, then the platform must notify the right holder of such match. This is very clearly based on the standard set in Klawischnik-Pisik case as interpreted by Advocate General in the Polish challenge again. And the second draft bill, on the other hand, allowed on these platforms to automatically block content when there is a high probability that a protected word will be communicated to the public in a way that infringes the author's rights. This is effectively identical copy of the Swedish proposal 52.0 paragraph. According to the explanatory memorandum, this high probability for infringement condition seems to be met already when the right holder has provided relevant and necessary information to identify and block protected works. This information has to be sufficient in relation to the identification technology that has been used. It doesn't have to be complete match with the content uploaded to the service. It is sufficient if it can be inferred that the question is about the same work. So as such, the second draft is placing heavy emphasis on the availability of identification information and related technology, while it does not set any substantive standards for the similarity between the two files. And no, there is no longer legal support for the user's content flagging mechanism that was available with the first draft. So there are also other interesting features to both draft bills, such as extended list of neighboring and related right holders, but those I can only address during the discussion with the time constraints here. So in my view, the first Finnish draft was better with its regulatory approach, as it was tackling many of the underlying issues with the Article 17. Now, on the hindsight, it would have been even in accordance with the fundamental rights requirements that the Court of Justice now established in its judgment to the Poland's challenge. While the second draft bill seems to provide higher degree of harmonization between member states, being fairly agnostic and open-ended than being like officially copied from patchworks of other Nordic countries, it does so at the expense of legal clarity, precision, and ex-ante safeguards for the users. This means that with the current approach, any authoritative interpretations on Article 17 provisions would be on the shoulders of the courts. Ultimately, this means CGEU. So the implementation of the CDSM Directive is still pending in Finland. The second draft became an official government bill, which is currently in the stage of parliamentary committee hearings. At the moment, and despite the Commission's pressure to push the implementation, it seems like the process will last until the autumn, at least, with some of the committee hearings being postponed to autumn. That means that the resulting act would come into effect likely only in the beginning of 2023. So thank you for your attention. That is all I have now with my narrow time frame.
Thank you very much, Samuli. That was actually quite a lot, also to ponder on, because indeed a delay objectively has been caused by the late release of the Commission guidance on Article 17, and then there were important cases pending before the Court of Justice, YouTube, and the Polish challenge. Now, yesterday I was attending a webinar in which someone suggested that the member states that are late, including Finland, might be wanting to push things even more, waiting for the final text of the Digital Services Act, which of course is presented as something that will not have a direct effect on the DSM Directive, but nonetheless will be relevant to the application of Article 17. So I would like to ask you whether you think that that is true for Finland, that indeed there might be an appetite also for this autumn discussion to see what the DSA eventually states.
Thank you for your question. I gotta say, I don't have any official knowledge of whether there would have been discussions like this, at least not available on the public. But because of this Constitutional Committee of the Parliament's hearing about this national transposition of Cooperative Digital Single Market Act directive was now postponed until the autumn session, that somehow, I would say, indicates to what you are saying. It is true that the national legislators are probably quite burnt up with all the platform regulation coming at them. So I think it seems process economically very wise, at least, that if they could concentrate all of those preparations more towards the autumn and have maybe better picture what they should be regulating now and what they can be leaving later as well. It's already been mentioned during this second draft bill discussions that some of the national copyright related questions have been also postponed until the unknown future when they would be implemented, and that might mean that some of these user rights questions that have been now addressed in this Court of Justice's judgment might be also somehow discussed later in the future as well. That is at least what some are arguing at the moment.
Thank you very much. Indeed, also when I read the latest, at least the latest one that I've seen, a draft of the DSA, it was as current as 16th of May. There are some provisions, I'm thinking, for instance, transparency in Article 13, that really echo the CJEU judgment in the Polish challenge. So clearly there is a close connection, and let's see what happens. Perhaps, the member states that were late in the end might got the best result of all, because for some member states that have already completed the transposition process, it might be already time to go back to the drawing board. And this might be the case indeed of the Italian transposition of Article 17, which provides, among other things, for an ex-ante blocking mechanism. So I would like to thank you, Samuli, for sharing the Finnish experience with us, and ask Simona Lavagnini to tell us about the Italian transposition of Article 17. Simona, the floor is yours.
Good afternoon, everybody, and thanks for having me today. My contribution focuses indeed on the Italian implementation of Article 17 of the Digital Market Directive, and more specifically on the complaint and redress mechanism. I will mainly deal here with two issues due to the time constraint. The first one relates to the fact that, according to the Italian implementation, the contents uploaded by users and notified to the platforms by right holders as infringing must remain disabled until the complaint procedure is completed. And this Italian rule is diametrically opposed to that adopted in the German legal system, for instance, where the new provision says, on the contrary, that in order to avoid disproportionate blocks, the presumably permitted uses shall remain visible to the public until the conclusion of the complaint procedure. And from this follows that in two important European countries, opposite rules will apply as of today. And this is, of course, an outcome that hardly corresponds to the goals of harmonization, which are typical of a directive, and also could possibly lead to difficulties in implementing the different procedures in the various countries, and also implies a different treatment and inequality of treatment in the different territories for the interested parties. One thing is also relating to the issue whether the Italian solution is in line with the need to respect the fundamental rights to information and expression. Now, I have thought a lot about this. And of course, I think that it can be said that in most cases, according to my knowledge of the current technology, the contents subject to the complaint mechanism should not be those manifestly infringing, as the latter should in general be blocked at a prior stage by the filtering technology applied by the platforms. Therefore, the content in question will be blocked and will be more concern the exercise of an exception. If this is the case, one could indeed argue that the stay down during the complaint mechanism could impact on the freedom of expression and information of the users. Also, for the same reasons, it is possible to argue on the contrary, because I think that infringing content in this case should probably be minor. I think that Eleonora has highlighted that one study of the technology used by YouTube evidences that indeed there are quite a few contents that are challenged after the first filtering technology is applied. Also, right holders will need to motivate their request, and these should lead to rather well-grounded or better founded notices. In the presence of a written complaint, therefore, the disabling of content for the duration of the procedure could be justified for two reasons. First of all, because it could be a fair means to protect the intellectual property right on the one hand, which is one of the goals of the directive. But on the other hand, it could also protect the user because, of course, provided that the mechanism is quick and based on robust principles and methodology, the fact that the content will remain disabled until the end of the, again, quick mechanism could protect the user against possible later action by the right holders in case the content was indeed found as infringing. One second issue that I discuss is the role of the authority for electronic communication that, as we already know, has been entrusted with a lot of function by the new implementation law, something that leads into thinking that the authority is a kind of new regulators in the field of at least online copyright. Now, the authority for electronic communication in this respect has been entrusted with the duty to issue the guidelines for the complaint and redress procedure to be adopted by the online platforms, as well as a regulation for administering appeals against the decision issued by the online platforms following the complaint procedure. Now, it is a quite long history to tell how the authority was set up, which was quite a few years ago for different tasks, mainly to regulate electronic communication operators for matters different from copyright protection. However, it is important to highlight that over the time, the authority has acquired a lot of additional powers, also replacing some powers that the Italian Collecting Society, the semi-public CIA had acquired over the time. And that, of course, appear to be in contrast with the role of Collecting Society as one of the parties. So there was the need to a third-party authority, and AGCOM actually in 2013 issued a regulation on the field of online copyright infringement, a regulation that has been heavily criticized and challenged at the time, but now, after some years, after some amendments to the law, and after a few decisions by the various administrative courts, we know that the regulation has been stabilized and actually represents a kind of best practice, even at an international level, because it allows the possibility to act against online infringement, even carried out by foreign websites, which are generally difficult to address, and obtain a decision, an order, within a very limited time frame. In fact, the regulation provides for different procedures. Some are more lengthy, lasting even 35 days, but some are very short, like the interim procedure, which is a procedure based on urgency, an ex parte procedure lasting 3 days only. And this, of course, is very important in the online environment. Now, the issue here is that probably the regulation issued in 2013 will be used as a kind of framework to also inspire the regulation to be issued on the complaint and redress mechanism decisions. The thing is that it has to be considered that the regulation issued in 2013 actually only related to very blatant infringements, where basically there was no need to take any kind of thoughtful decision as to whether an exception was exercised or not. This is not the case probably for the regulation that the authority has to issue. And this is the reason why it is important to find a correct balance between the need, in my opinion, to prefer adversarial procedures, therefore procedures where the other party is summoned before the decision is taken, and the need, of course, to be as quick as possible, given the fact that we are dealing with the online environment. There are also many other issues that would need to be addressed in the future, like what happens if the AGCOM procedure is abandoned by one of the party and the party goes to the ordinary authority. In this case, probably the AGCOM loses the possibility to continue the proceeding. But what happens if the decision is taken and then the party would like to appeal against it? In Italy, we have a completely different procedure between the administrative path and the judicial part for ordinary matters. So, I mean, it is possible to have a conflicting decision, to have two different proceedings pending, one before the administrative court and one pending before the ordinary court. What kind of value would have the decision taken by the authority before the judicial ordinary court? We will see in the future, because certainly this will, I think, start litigation, and probably in the future we will need to discuss this. Thank you very much for your time and your attention.
Thank you so much, Simona. The picture that you paint, I don't know whether it is exciting or depressing. Because of course you opened your talk by highlighting how the Italian solution is, for instance, different from the German one. So also from the point of view of compliance on the side of platforms, they might need to undertake geo-blocking of content offering, no? But now you are suggesting that even within the same country, such as Italy, you might have a diverging solution. So this sounds like a recipe for a headache, to say the least, no?
Yes, but you know, this change that the legislator has made in shifting towards a kind of administrative copyright law in online environment required us to see what happens in other kind of fields where indeed we have already seen that there is the possibility of conflicts between the administrative law, the administrative path, the decision taken by the administrative courts, and the ordinary courts. And since recently, the ordinary courts have held the view that a decision taken by the authority of competition, for instance, have privileged value. In my opinion, this means that if there is a decision taken by the authority for communication that you want to challenge, you need to go probably before the two different authorities, the judicial ordinary authority and the administrative court.
Got it. Thank you very much. There was also a question regarding AGCOM's competence, and it was raised by someone when we were discussing the Italian transposition of Article 15. And the question is whether AGCOM shall have expertise to arbitrate disputes arising out of the application of the provision. So it is not really a question of competence, but rather a question of expertise. So I don't know if Simona, Caterina, or Magali wish to answer this question.
Well, I can say that the piece of legislation that has entrusted AGCOM with this new power has not given additional resources. And this is probably the reason why, even though in the implementation law, the authority should have commenced issuing at least a consultation process at the beginning of this year, nothing has happened so far, not even in one of the different fields in which the authority has powers. Notwithstanding the fact that the authority is certainly trying to work to acquire more expertise, in my opinion, it's clear that the expertise they have is certainly diverse from the expertise that is needed in the various fields intersected by the implementation law. So who knows? I don't know really. I think this may create a big issue of, how do you say, maintaining things still and creating even bigger issues for right holders and other parties involved, because in this uncertainty, nobody knows whether the directive is completely effective, or if in the absence of this regulation still is not completely effective and needs and therefore is not applicable.
Thank you very much. I don't know if Caterina or Magali wish to add anything.
I completely agree with this take. No more resources were granted. There is some expertise, in fact, because it's not the first time that as an authority they're entrusted of calculating compensation or making parties agree on best practices. So they are not completely uncovered. They have quite a nice team on these matters. But if it's about negotiating and if it's about basically playing the role of an arbitrage, because that's the point, I think it's a step beyond what they did until now, and that might trigger further problems, which may make Article 43 reach court much earlier than what we believe.
Thank you. So now we move to Spain, and indeed we are glad to have Miquel Peguera to discuss with us the Spanish transpositions of Articles 15 and 17. So this talk will conclude our part indeed on the value gap provisions of Article 15 and Article 17. Miquel, the floor is yours.
Thank you very much, Eleonora. Thank you for having me. I'll try to be really brief and to the point. So my idea was just to highlight some issues regarding the transposition of Article 15 and 17 in Spain. Though a first quick word I would like to say regarding the way this transposition has been done, because it's been done through an instrument which is called the Royal Decree Law, which is an instrument foreseen for matters of urgency. So in cases that the legislation cannot pass through the parliament, the government directly enforces and enacts and enforces a piece of legislation, and that was the case. So that meant that the content was not known for the public, the content of the law, and it was simply all of a sudden overnight converted into law without the possibility of discussing amendments and so on. But now it is once the urgency, which was essentially the risk of being fined because being behind the schedule for transposition. The text has now been introduced newly with the parliament, so there is the possibility that some changes eventually are approved. But the transposition as such is now current law, and thus in the event that finally it's superseded by a different piece of legislation, that would be some changes on that. But regarding Article 15, well, as it's been said, Spain, like in Germany as well, had already a special scheme or special legal regime for press publishers, which well, it was a remuneration right, and it was a non-waivable right linked to an exception for users of press publications by society service providers, and it was compulsory, managed by collective managing organizations. So this obviously has changed now. The Spanish law transposes Article 15, and mostly verbatim, but with some tweaks that I would like to highlight. For instance, the right is granted to press publishers and to news agencies, whatever they could be. They are not defined in the law. Regarding, for instance, the short extracts or individual words or short extracts which are left outside the right, the Spanish transposition says not just short extracts, but those must be very short, or they may also be of little significance, both quantitative and in qualitative terms. So it's some elaboration on the definition, which may give rise to some problems in interpretation. Then, in addition to that, those short extracts are outside the right only where they do not harm the investments made by press publishers and do not affect the effectivity of the exclusive rights under this provision. So again, it's a kind of narrowing the terms provided for in the directive, and thus widening or broadening the right for press publishers, which also may give rise to some compatibility issues with the directive. And it also establishes some elements for the negotiations for the authorizations to be granted. Simply, well, those negotiations must be carried out under the principle of good faith, excluding the abuse of dominant positions. But in addition, it says that some transparency obligations must be established for service providers, and also that the agreement cannot include other unrelated obligations. Okay, well, and some other little points, but quickly we'll go to Article 17, and essentially two elements there. Well, first, for the before that was discussed, okay, the large amounts, Leonora, you were referring to what a large amount of content may mean. Well, Spanish transposition says in the definition of the of those providers that they store either large amount or content with large audience in Spain, which is not exactly the same. It's kind of a little bit confusing what that could mean in practice. Of course, there's also this terminology of using biggest efforts instead of best efforts, like also in Italy with massimi sforzi, I think is the case. But then most importantly, when it comes to live events, like for instance, though it's not said like that, like a football match or something like that, providers must remove or disable access to the contents during the retransmission of the concerned live event, which is a tricky thing. To begin with, this is not said as such in the directive, but then also retransmission of a live event may not necessarily involve storage of content, so it's not clear whether it would be under the scope of the provision to begin with. And in addition, it arguably makes it more difficult for, or may make it more difficult for providers to comply with the conditions to be free from liability. And then another relevant peculiarity is that Spanish law says even if the content sharing service provider has done all the efforts and fulfill all the conditions in Article 17.4 to be free from liability, if unauthorized content happens to still be there, and this causes a significant prejudice to right holders, the right holders will be able to bring legal actions to compensate that harm, legal actions such as the one for unjust enrichment. And this is, well, this is very difficult to be, this is hardly compatible in my view with a directive, as it would mean that even in those situations where the directive has decided not to consider liable the provider, right holders nonetheless may still claim compensation damages from them. And I stop here. Just let me mention that as similarly, like in Italy, like Simona was noting regarding the redress mechanism, in Spain also the transposition requires that the content shall not be accessible on the platform while the complaint, the user's complaint is being decided. And thank you very much.
Thank you so much, Michele. You have been able, to provide us with a detailed and very interesting overview of the Spanish solutions. So I would like, to ask you to comment on two matters. The first one is what you think about this ex-ante blocking system. Is it compatible with what the Court of Justice said in the Polish challenge case? And secondly, you touched upon these live streaming services, and for those in attendance, there is currently a discussion going on in the Nordic countries, including in Sweden, as to whether indeed this live content makes one qualify for the definition of online content sharing service provider. And so far, the direction that the Swedish legislature might be taking eventually is to exclude these subjects from the definition of online content sharing service provider. So if it is okay, Michele, I would like you to comment on these 2 points as to what you think the correct approach is. Thank you.
Thank you very much. Well, as to the filtering issue, that's a very tricky issue. So after the Poland judgment, it is on the one hand, it is the directive has enough safeguards as to make it compatible with the freedom of expression, but still not any filtering mechanism would be okay, as those must fulfill or must be able to properly distinguish between lawful and unlawful uses, which Probably in practice, it's a question really difficult to achieve, at least with a high degree of precision. So in the Spanish transposition does not directly elaborate on the use of these content recognition technologies, but still there is this discussion of whether transposition should introduce some additional safeguard or not, or it is enough just to do what it has done, which is to transpose it verbatim with the addition of these two elements of live content events and also this unjust enrichment thing. And as for the live events, I was not aware of this Swedish discussion, but yes, I think it comes to the very same point. So one important thing is determine whether or not this falls within the scope of the definition. And so far, the Spanish legislator has simply established this. This is current law, and we will see whether in the current legislative process this is amended, though it is not clear so far. Thank you very much.
Thank you very much. We now leave the discussion of Articles 15 and 17, and we move on to the provisions on contracts. And in particular, we are happy to hear from Ludovico Bossi and Jacopo Sciolla on the Italian transposition, in particular of the transparency obligation in Article 19 of the DSM Directive. So please guide us through the solutions identified in Italian law. Thank you.
Good afternoon, everybody. Thank you very much, Eleonora, for hosting our contribution in the special issue and also for convening this webinar. I would say very timely because Article 19 entered into force yesterday, so on the 7th of June 2022. So it is very timely. We will split our 5 minutes with my co-author, Ludovico Bossi, which is next to me, even if we have different screens. He will address the scope of application of Article 19 and the very object of the duty of transparency. Next, I will say a few words on sanctions and on balances and limitations and try to draw some conclusions. Thank you very much. Ludovico, the floor is yours.
Thanks, everybody. Thanks, Jacopo. We are talking about Article 19 of the directive, which establishes a transparency obligation on the exploitation of works and performances. So we consider the Italian transposition quite interesting because in many cases, the Italian legislator went beyond what the directive required in order to better protect authors and performers. In particular, this high protection is a fair erosion in the transposition of this article. In general, just consider that this measure has a broad scope of application because it applies to all authors and performers, excluding just authors of computer programs, and to all kinds of contracts, including, in our opinion, proportional remuneration and lump sums. So probably in the future, this measure will have a major impact in the sector. So now, in specific, what are we talking about? The directive required some information to be provided to authors and performers by the contractual counterpart when there is a license or transfer of exclusive rights. Such information were in particular the remuneration due, the revenue generated, and the modes of exploitation. The Italian legislator, with a new article in the Italian Copyright Act, required additional information, in particular the identity of all the persons concerned in the license and transfer, in particular secondary users, then the advertising revenue, So it's a very specific information, so the degree of analysis is quite high. And then in the case of on-demand platform, also the number of subscribers, views, and purchases. Secondly, this information has to be provided at a certain frequency. In the directive, this frequency is at least once a year. The Italian legislator significantly reduced this period up to 6 months. So we have half of the period of the directive. Thirdly, if the first contractual counterpart has not all the relevant information, additional information can be required to sublicensees. This is what the directive said. But the Italian legislator decided that this request can be made directly by authors and performers and not only through the contractual counterpart. So this procedure is more immediate. And finally, this is a mandatory provision, so it can't be overwritten by the will of the parties, but what at an international level, because we know we have a free choice of law applicable to the contract. Well, on this point, the Italian legislator considered this measure expressly an overriding mandatory provision, pursuant Bruxelles recast. So what does it mean? It means if the case is decided in Italy, well, this measure will apply regardless of the choice of law. And if the case is not decided in Italy, well, this measure could still apply as long as the obligations arising out of the contract have been or have to be performed in Italy. So we have a nice standard of protection. For the next points, please, Jacopo, and thanks for the attention.
Thank you very much. The Italian legislator vested with the power to surveil and monitor the application of this duty of transparency, the Italian Communication Authority, the so-called AGCOM. This is nothing new under the sun because, as already Simona told before, this authority, this administrative authority, was already vested with strong power to police copyright online infringement since 2014 with many concerns and critics. What is important here is that the sanction that may be applied by the authority amounts to 1% of the global turnover of the infringer. This is the path, the direction already established by the European legislator, for example, within the General Data Protection Regulation. So this kind of percentage is the best way for legislators in order to address the different dimensions of potential infringers. What is quite noteworthy, I think, of the Italian transposition of Article 19 is that in case no communication, no release, no disclosure of the information has been done by the contractual counterpart, there is a legal presumption that the original remuneration was not fair, was not appropriate. This automatically triggers the application of the remuneration adjustment mechanism and without any need to fulfill the condition set forth in Article 20, paragraph 1. So it is not necessary anymore to show that the remuneration originally agreed turns out to be disproportionately low compared to all the subsequent relevant revenues derived from the exploitation of the works or performance. So a legal presumption that make really easier for the authors or performers to show the right to claim, to give evidence of the right to claim the adjustment of the remuneration. I think that in these, the Italian legislator took note of the experience of the German legislator that and the German court that face the difficulties of authors to show, to give evidence of this disproportionate in the remuneration. Next, I would like to focus on the balances and limitation to this duty of transparency, mainly on the proportionality test set forth by paragraph 3 of the directive. Paragraph 3 reads that the transparency obligation shall be proportionate. The same proportionality clause is mirrored also in the Italian Copyright Act, but surprisingly, the Italian legislator did not specify in any way the meaning of this proportionality clause. The European legislator instead suggest a twofold directions for applying this proportionality clause. This thanks to a partial limitation of the scope of application of the duty of transparency, paragraph 3, and through a total exemption from the application of the duty of transparency, pursuant to paragraph 4. The limitation states, according to paragraph 3, that the transparency obligation could be reduced in its object, so the information to be released can be reduced, if the cost for getting such information for the contractual counterpart is too higher in respect and disproportionate in respect of the revenues got by the exploitation of the works. Instead, paragraph 4 enables member states to introduce an exception when the author or performer's contribution is not significant, having regard to the overall work or performance. No exception, no limitation are mentioned at all by the Italian legislator. So we do not know how to interpret this proportionality clause. Probably we can interpret it in the light of the directive, but this is totally ambiguous. Furthermore, the Italian legislator just specify this proportionality clause thanks to the reference to the duty of confidentiality of authors and performers. So basically, as established already by the directive, authors and performers should keep the information got by the contractual counterpart confidential. But actually, it seems to me that this duty of confidentiality is not an application of the proportionality test, as would seem from the Italian transposition of Article 19, but to the contrary is an application of another principle established by the European legislator, which is the principle of balances of rights, which is established in Article 18, paragraph 2, I think. So I think that the big open issue from this Italian transposition of Article 19 is the interpretation of this proportionality clause. Thank you very much.
Thank you to you both. I think that this was a very interesting overview, because the truth is that yes, there are these provisions in the directive, but they don't really say much about what member states should be doing. So also here it is likely that we will have different approaches across different countries. And indeed, if we look at this topic of transparency from a comparative perspective, there are also a couple of issues that come to my mind that might be worth tackling. And they are, first, whether this obligation of transparency translates into a right of authors and performers to audit the books of their contractual counterparts. And secondly, what happens in the case of an employment relationship, because also there are some stakeholders that are rather concerned about what will happen when these transposition measures are finalized. So I don't know if you, Jacopo, or Ludovico feel like commenting on these points.
Well, first of all, we have to say that national legislator enjoyed great degree of discretionality in implementing this last part of the directive. And in any case, it's a step further, because for many time the regulation of this matter, the copyright contract law, has been considered unnecessary or premature by the European legislature. So we have now a starting point, and we have to make this provision to be effective, really. Jacopo, if you want to say something.
Thank you, Eleonora, for your questions. I think it's rather quite difficult to give an answer. This Italian transposition lacks of really indication on this point. The contractual counterpart maybe could be the employer. The words used by the Italian legislature are wider than those used by the European one, because the Italian legislature does not refer only to the sublicensees, but more in general to subjects that are involved by the contractual agreement with author and performance. But I think this is not enough in order to clarify your point, what happened with the work for hire doctrine, etc. And then I think it lacks completely the so-called sector-specific approach. So the European legislator gives this possibility to differentiate the information to be given depending on the typology of sector, and this approach has not been exploited by the Italian legislator at this point. But I think that with the power vested on the administrative regulatory authority, we should expect some clarification by the authority itself in the next month. Thank you very much.
Thank you very much. And now we move on to the final article in our special issue, that is a Czech perspective on dispute resolution in the DSM Directive. And we are very happy to have with us the author of this article, who is Jelizaveta Juřičková. Apology for the mispronunciation, which I'm sure I've just committed. And the floor is yours. Thanks so much for being with us.
Yes, thank you, Professor Rosati, for having me here. And I believe that we all are tired, so I will try to be very brief. So in my paper, I examined how the Czech transposition proposal deals with alternative dispute resolution requirements under the DSM Directive. And I think that a short recap is in order. There are basically two requirements to set up ADR under the DSM Directive. The first one is contained in Article 17.9, and it concerns creator disputes. In other words, disputes which arise from the user content being blocked and where the parties are user and rights holder. And the directive foresees two mechanisms for resolving these disputes, internal and external. And I will only deal with the external mechanism, where even the Czech transposition has to show certain degree of creative choice. And the second ADR requirement is contained in Article 21 of the DSM Directive, and it concerns mainly disputes arising from the mechanism for contract adjustment in case of additional remuneration for authors, otherwise known as bestseller clause. So the Czech proposal offers the same solution for both of these types of disputes. It establishes a specific kind of mediation, which is performed by people who have expertise in copyright and some basic skills in out-of-court dispute resolution. And this mechanism has already been used before for collective management negotiation, so its scope was enlarged. What I believe could be problematic with this design of dispute resolution is that disputes of different nature are all gathered under one catch-all provision, and they're given a uniform way of resolving them. So I asked myself, is the universal mediation-based solution really suitable for both of these very different DSM directive disputes? And to answer this question, I decided to examine the nature and purpose of mediation. And I found really useful the thoughts of the esteemed Lon Fuller on the subject. Now, firstly, above all, mediation is an interest-based procedure. That means that it works best when there are multiple issues at stake. And the primary task of mediator is to find the underlying needs and interests of the parties and try to expand them so that there is more room for negotiation, and then the mediator can help the parties to find an acceptable trade-off. So if we try to apply these basic principles to creator disputes, we can see that this does not work very well, because in their core, creator disputes are fairly straightforward. They generally concern interpretation and application of copyright law, especially provisions on exceptions and limitations. So the outcome of the dispute is binary. Either the use of the work is legitimate or not. So we can see that here is basically no room for reconciling conflicting interests of the parties and for any trade-offs. Now, secondly, according to Fuller's theory, a dispute is not amenable to being resolved by mediation if there is a lack of cohesion and interdependence in the underlying relationship between parties, which I believe is the case with creator dispute, because this requirement to provide EDR for these cases was primarily meant to benefit the user, and its purpose is to reinstate wrongfully blocked content. And if we take into consideration that the mediation is a voluntary procedure, I simply don't see any pull for rights holder to participate. Why couldn't they simply walk away from this dispute? Well, on the contrary, if we try to apply the same considerations to disputes under Article 21 of the DSM Directive, which, as I said, concern additional remuneration, we see that mediation works quite nicely. The first reason is that the parties to the dispute have exactly the right type of relationship, according to Fuller. They depend on each other to a high degree. We could say they depend on each other for a living, especially if you think about authors of books, press publishers. And besides, there is quite a lot of complementary interests involved. And this again offers some room for negotiation. For example, I don't know, future collaboration, publicity, access to a good editorial team. And most importantly, the subject matter of the dispute is perfectly suitable for mediation. Because as Fuller writes, mediation is quite often directed towards creation of rules that govern the relationship between the parties. And here, basically, the task of mediator is to either renegotiate the existing unfair contract or to help the parties write the new one. So this means that mediation basically creates the relevant norms which will govern the relationship between the parties for many, many years to come. And well, to sum up, the result of my article was that that creating a universal vademecum, universal solution for DSM disputes simply won't work, because while mediation is great for contract adjustment disputes, it is completely unsuitable for content removal disputes. And in my in the final part of my paper, I also offered some suggestions as to how to optimize the alternative resolution of disputes by providing the mediators with a certain technological backing, but I believe that I'm running out of time, so I will leave it to discussion. Thank you very much.
Thank you very much. This was very insightful and interesting. Let me follow up with a question for you. You seem to think that indeed this mechanism works fine for contractual disputes, but we were hearing from Jacopo just a few minutes before that a sector-specific approach, even within contracts, should be provided. So I would like to ask you what you think of that, and whether you think that even for contracts, there should be more room to accommodate the actual diversities of different contract types and different industries.
Well, I believe that basically in the case of Czech transposition proposal, we have this specific sector-specific approach because the mediator, which basically helps the parties to negotiate this contract, is not just any mediator, but a person who has this specific copyright knowledge and who had to get certification from the Ministry of Culture to pass quite difficult exam, etc. Well, I believe that we have the specific approach, and I believe that, of course, this is the right path because, the complexities of copyright contracts seem to grow, and the length of the contracts also. So I believe that a simple layman, because, for example, in Czech Republic, mediators don't necessarily have to have even legal education, will get lost. And how could he fulfill the task of helping the parties?
Perfect, thank you very much. We have reached the end of our webinar. We are precisely on time, unlike some member states with their own transposition of the directive. So let me thank all the speakers who have participated in today's webinar, and of course all the participants who have joined us. As you see from the chat, you can access all articles of this special issue through our website, and it is also possible to get in touch with myself or my colleague Sarah Harris to discuss any ideas for articles that you may be thinking of writing or that you have ready. So thanks again for being with us this afternoon, and thanks to the authors. We look forward to receiving further articles from them in the near future, also to update us on how indeed the national applications of the provisions that we have discussed today indeed are going. So thanks again, and have a nice rest of your day. Thank you.
Thank you. Bye.
Thank you very much.
Thank you.
Bye.
Thank you. Bye-bye.
Thank you.
Thank you.